Right, hello everyone, good morning. I think that there's quite a few people coming in all the time, so but we're going to start because we're at 11 o'clock. So welcome to the BFA webinar, and today I'm super pleased to be joined by Philip Deja of Streathers Solicitors. Streathers Solicitors are our BFA legal partner, and when we first met and were introduced to Philip, I think Lucy and I both knew that they were our perfect legal partner here at the BFA. They take time to understand people, to listen to their challenges and what they're going through. Really good at cost saving, and they just had a brilliant mentality. So we were super pleased when Philip and Streathers decided to join us as our BFA partner. So today on the legal clinic, Philip will be taking us through lots of different stages in the life cycle of a footwear business. So focus on key legal issues, potential triggers you may experience along the way. Philip will also highlight pitfalls to avoid and offer pragmatic, cost-effective solutions. What I love about Philip is he uses real life examples, and he's had a lot of experience with other footwear businesses, which again was a real good advantage for us when we first started working with Streathers. So Philip will use real life examples. He'll offer insight into key issues for footwear businesses, such as supply chain relationships, fundraising, research collaborations, mergers or acquisitions, and succession planning. So just to let you know, a little bit of housekeeping, we are recording, so therefore it's available later on if your colleagues want to listen to this. We're recording it. It will be available probably by the end of the week. We are going to have a Q&A session after Philip's finished. If you would like to ask any questions, put your hand up or put it in the chat box, because I'm sure there will be lots of questions afterwards, and Philip's prepared for questions, because I said a lot of you lot are very vocal, which is good. So anyway, enough about me. I'm going to hand you over to Philip and enjoy the webinar today on footwear businesses and the law. Over to you, Philip.
Thanks, Polly, for your kind words introduction. And hi, everyone. I'm sure you don't want to be lectured on the law for the next 20 minutes. But it seems to me that footwear businesses, and especially smaller or growing footwear businesses, are in a difficult position in relation to the law. I'll try to illustrate this a little from my own personal background, and apologies to those of you who already know a bit about me. I trained and qualified at one of the largest international city law firms and practiced there for about 5 years. Once I'd had enough of giving technical academic advice to multinational corporations, I joined Streathers Solicitors about a decade ago to set up a broad corporate commercial practice across Streathers North London offices. I still have a few larger business clients to this day, but more than 90% of my work now is for SMEs and startups. Even though I'm still doing technically similar legal work for businesses, I must say I haven't regretted leaving the city for a minute. I find it so much more stimulating and satisfying becoming the trusted advisor for entrepreneurial founders and owner-managers, helping real people who've built up their own businesses and are passionate about seeing them grow. But back to the point of this talk. My main clients when working in the city were Royal Mail, Coca-Cola, Amazon, other multinational corporations. These companies have annual legal budgets of hundreds of thousands or even millions of pounds. You don't need me to tell you that's not true of most footwear businesses. But the fact is that the law is essentially the same for all businesses, and footwear businesses face many of the same legal issues as multinational corporations. So my job, in a nutshell, is to help footwear businesses find pragmatic but effective solutions to their legal issues in a way that doesn't cost the earth. Now, obviously, I can't solve all of your legal issues in the next 20 minutes. But my aim for this talk is to highlight some of the key legal issues and pitfalls that footwear businesses face, as well as some common myths and misconceptions, and then give you some hints and tips to help you start to find pragmatic solutions, sometimes without needing the services of a lawyer in the first place. As Polly already touched on, the way I'm going to structure this talk is to walk you through some of the key stages in the life cycle of a footwear business and related legal triggers. peppered with real life examples from my own recent experience. Now, I'm not a big fan of awkward silences, so I won't pause at every stage for questions. But as Polly mentioned, please do feel free to send a message on the chat or stick up your hand to interrupt me at any point if you do think of a question that's pertinent. Otherwise, there'll be plenty of opportunities to ask questions in the Q&A session at the end. Okay, so let's start at the beginning, starting out. Most businesses start trading on a sole trader or informal partnership basis to test the water, and footwear businesses are no exception. Of course, in an ideal world, you'd make sure that from day one, you have the protection of a limited liability corporate entity and watertight written contracts or standard T's and C's in place with all your customers and suppliers. And that does happen occasionally in practice. For example, if experienced entrepreneurs or professionals start a new business, perhaps with private equity backing, and know that they're onto a winner or have valuable intellectual property they need to protect. But of course, in the real world, it often doesn't make sense to spend thousands of pounds on drafting a beautiful suite of nice legal contracts before you know if the business is actually worth it. So you might have to rely on informal agreements with smaller customers, and except there's no way you'll be able to negotiate with your big suppliers in any event. You might even be able to recycle standard terms from larger similar businesses who you know have decent legals in place and operate on a similar basis to you. So the next legal question to consider may be whether to incorporate your young footwear business as a limited company or other corporate entity. Now, this is often primarily a tax and accounting decision in practice on the basis of advice from your accountants. But there are important legal issues at play. The clue is in the name. Limited liability can be an important protection for business owners. Having said that, this potentially powerful protection can often be tempered by banks and other important counterparties insisting on personal guarantees from the owner managers or directors. I'm happy to help with incorporating any limited company, but I have to say it usually doesn't make sense to pay your lawyer hundreds for incorporating a simple or standard off-the-shelf company. It might be that your accountant can do it for you at their own cost. They always want more company clients on their books. Or there are decent, affordable online company formation agents out there that can help. You can even DIY it as long as you're comfortable with the various annoying forms. One thing I'd say though is just be careful to sense check whatever comes out. For example, in a recent case I was acting on, my new client, the company I was advising, had constitutional documents in place that stipulated that any decision had to be taken by at least 2 directors. But this was a sole director company. So technically, all decisions the company had taken to date could be found to be ultra-virus or unlawful. Okay, the next legal trigger point that often comes up is a factor of growing success, making more money, plus potentially entering into bigger value contracts with bigger, scarier customers or suppliers. At this point, your business actually has something to lose, and it's probably well worth spending something to give you the peace of mind of having decent legal protections in your contracts. A cost-effective way of achieving this can be to get a relatively straightforward set of T's and C's and/or template contracts prepared that reflect your usual commercial terms with most customers or suppliers. That way, you might be able to get most of your counterparties to sign up to your standard terms, with you filling in the blanks and perhaps negotiating the odd commercial amendment yourself. Then you might only need to engage your lawyer to assist with the odd question or issue in negotiations with particularly important counterparties. If a customer or supplier is insisting on wholesale amendments to your standard terms or on using their own standard doc, then it will be up to you to take a view as to whether this is an important or attractive enough client commercially to merit engaging your own lawyer and or living with their terms, or whether it's better to live without. A successful client of mine recently fed back that this approach has helped give them peace of mind and to sleep better at night, and was a price well worth it. One particularly thorny legal issue for footwear businesses, even at a relatively early stage, can be the need to enter into relatively complex cross-border contracts. For example, with factories in Portugal or Vietnam, say, or international franchising, distribution or research arrangements. This can be another point, unfortunately, where the ideal world and practical reality can be quite far apart, because with the best will in the world, it may be disproportionate for a relatively small footwear business to engage specialist lawyers across multiple jurisdictions to advise on those kind of cross-border arrangements. It might be that the best you can realistically achieve in practice is to engage your regular lawyer or business advisor who knows your business and the key issues you face to advise on, say, a Chinese law manufacturing contract, which they're technically not qualified to advise on, from a first principles basis. This may at least help to flush out the key commercial and legal issues. It's actually something I'm supporting a young footwear business on this week, in fact. And even if you can't achieve full legal comfort, the practical best case may simply be to try to avoid signing up to a long contract under which you're overly reliant on a single manufacturer or supplier without at least working closely with them for a period of time and getting as much independent intel or feedback from others as possible, perhaps even through the BFA. Another issue that's often particularly pertinent for footwear businesses is intellectual property, IP. As well as the usual trademark or brand issues that are common to most businesses, footwear businesses may need additional IP protections, such as registered designs protecting the shape of shoes and/or patents protecting new inventions. Thankfully, as many of you know, the BFA already has an excellent long-standing IP partner, BFA Legal, who are experienced experts at advising footwear businesses on these often tricky and challenging IP issues in a pragmatic way. Okay, so let's say your business is growing, you're confident it's going somewhere, but you need funding to take it to the next level, say to expand production or open new retail premises. One option, of course, is loan or debt finance. In practice, if you're going to a bank for a loan, whether a high street institution or a smaller private bank, there'll be very little scope for negotiation in the legal terms, if you can get a loan at all in the current climate. So actually, probably your lawyer can't be much help when it comes to negotiating the loan documentation. Although, of course, we're always happy to advise if you've got specific concerns. As already touched upon, in lending to a relatively small private limited company, it's very likely that the bank will insist upon a personal guarantee from the key director or directors, and they'll need to obtain independent legal advice. Hopefully, it goes without saying that PGs are generally bad news and should be avoided wherever possible. But if a relatively young company needs a loan, you might have no choice. One trick of the trade that's perhaps worth mentioning here is that because it's the bank that needs guarantors to get this independent legal advice, not out of the goodness of their hearts, of course, but to make sure nobody can wriggle out of a personal guarantee by saying they didn't know what they were signing or pleading undue influence or similar. So occasionally it can prove possible to convince the bank to cover your legal costs for obtaining this ILA. Also, I often assist with private loans, whether from business contacts, private equity, family members or friends. I'd say it's always important to get a decent legally binding loan agreement in place, but normally we can keep this relatively straightforward, especially if the parties are happy with only one lawyer being instructed. An alternative source of funding is, of course, equity fund investment from new shareholders. Now, these can be friends and family, business associates, angel investors, or other private equity funders who believe in your idea or business and that they can get a return on their investment. Even where the only shareholders are trusted friends or family, I would always strongly recommend getting at least a straightforward shareholders agreement in place, to make sure everyone knows where they stand and how the business will be run, as well as seeking to deal with potential issues further down the line that you might not have considered yet. For example, a shareholder passing away or needing to exit. Again, we can usually keep the legal costs down if all parties are comfortable relying on a single lawyer acting for the company to draft the documentation. Although, of course, each party will always have the option of getting their own independent legal advice if they have any individual concerns. The required legal documentation will probably be more complex, onerous, and require greater negotiation if there are arm's length private equity investors involved. But of course, this may well be commercially worth it if they're willing to provide significant levels of investment. There's often a delicate balance to be struck between getting in the funding that the business needs to help it grow faster and more strongly, but without giving up too much control or ownership to equity investors and/or having to service unsustainable level of debt to lenders. Moving on, as any business grows, it will often consider taking on employees, whether junior or senior, part-time or full-time, temporary or permanent. An alternative option is taking on freelance contractors or consultants, which may carry less long-term commitment, but may come at a greater short-term cost. Either way, in my view, it's always well worth putting written contracts in place, whether consultancy agreements or employment contracts. This is one area I've seen in practice where saving money now by not bothering to put into place appropriately tailored legally binding contracts really can come back to bite you later. We can often prepare 1, 2, or maybe even 3 relatively straightforward template contracts tailored for the main roles within your business so that you can potentially minimize ongoing legal costs by filling in the blanks yourself in the template for multiple employees or consultants, as long as they're hired on similar terms. Another area where a stitch in time really can save 9 is disputes. Clients often realise when a letter comes through the door threatening litigation that it's probably worth picking up the phone to their lawyer. But I do quite often see cases where clients have tried to deal with disputes without getting lawyers involved to save money. But by the time we're instructed, the matters become so much more complex and problematic, and the client might have shot themselves in the foot by saying the wrong thing in correspondence, for example. At a more mundane level, debt collection is a common issue. Where your business is offered relatively small amounts, it often doesn't seem worthwhile getting lawyers involved. But of course, it's the most frustrating thing in the world having to write off debts. One arrangement we sometimes put in place with appropriate clients, if they regularly or fairly regularly have customers failing to pay, is that assuming that they have a nice standard watertight standard contract or T's and C's in place, is that we can effectively draft a standard form legal letter tailored for that business and its T's and C's, and essentially fill in the blanks each time for a low fixed fee. And then for those non-paying customers, getting a scary letter from a solicitor on a solicitor's letterhead will often prove a helpful encouragement to pay up, shall we say. Another legal trigger we often come across is finding or moving premises. Often where this is a short-term commercial lease, which can be retail, office, manufacturing space, we can keep the process relatively quick and straightforward, especially if you're comfortable to live without some of the usual searches or due diligence that you'd rightly insist on for a longer term, higher value lease or property acquisition. One arrangement that we've helped out with a fair amount recently is buying freehold premises, so buying the property in your own personal name or through a holding company, and then leasing the premises back to your trading company. This can provide a good investment or pension, but obviously it depends on your financial and tax circumstances, and you should certainly seek the advice of an appropriately qualified and experienced accountant or specialist tax advisor before going down that route. Finally, mergers and acquisitions might not seem relevant to all of you at this stage, but as your business grows, it might make sense to make a tactical acquisition or even merge with another complementary business. Beyond that, succession planning is something every business owner needs to consider sooner or later. And unfortunately, many leave it too late. There will inevitably come a time when you're either looking to change your career or life or simply retire. And if your business is successful, it can be a real shame just to wind it up. This might become relevant sooner than you expect. Recently, I helped a relatively young client who wanted to move out of the profitable business he founded to spend more time with his young family. Now, he was able to agree to sell the shares in his company to another business that was a client of his and looking to expand into his niche. And so he's gradually winding down his involvement over the next few months, whilst receiving a life-changing sum in return. Okay, so that's a whistle-stop tour through some of the typical stages in the life of the footwear business. So let's move on to the Q&A. Polly, will you take the lead on this?
Thank you, Philip. That was amazing. And I feel like I've learned lots as well. So really useful, and especially because you're fully aware that the BFA membership incorporates lots of SMEs, and they're always the ones that, you know, like you say, haven't got lots of money and need the help. And essentially, they're always really good at footwear. But as we say at the BFA, you need you need other people to help run your footwear business. So let's see if we've got any questions. Oh, Neil, I've just allowed you to talk if you want to ask your question.
Hi, Polly. Hi, Philip. I have a question about intellectual property. So in the UK, I own the trademark of my brand, which is valid for 10 years under the limited company. But I have now plans of entering other markets, say Asia and the EU. And because the UK is no longer part of the EU, do I need to register that trademark in the EU as well, only for the purpose of becoming a wholesaler?
That's a real good question, Neil, and it's definitely well worth looking into. And I should say, you're holding my hands up straight away that as I sort of briefly mentioned in the talk, IP is one area where it's well worth speaking with specialists. And you know, I'm not a specialist in IP, so you may or may not have already come across them, but BFA Legal, as I mentioned, are the sort of the official IP partner of BFA, and I know, I mean, they've been working with footwear businesses actually for significantly longer than me, and I've worked with them a lot, and they're very good at giving sort of pragmatic, straightforward advice. They're top specialists, but at the same time they have lots of SME clients. So definitely I'd recommend that you have a word with them in the first instance.
Neil, I can put you in touch with William Miles, who's BFA. So how we have it at the BFA is that Streathers are general legal person to go to, and then BFA, because IP is so specialist, you tend to always have specialist IP lawyers, and that's what BFA are. So for any legal requirements, it's either Streathers or BFA, but I can put you in touch with William at BFA, Neil, if that helps.
Thank you, Polly. Thank you, Philip. I'll reach out to them.
Thank you.
Good stuff. Yeah, sorry not to give more specific answers.
Any other questions? Right, I've got a couple that have come up here. So I think, Philip, it shows that you had a good talk, because normally there's lots of questions. It's because you haven't followed things. So I've just got a couple of questions. So what would you say are the key issues to consider when it comes to selling a business or succession planning? And I'm asking that because we actually do have quite a few people within the BFA as members that either want to, they've grown the business sufficiently, they want to get out, like you said earlier, a bit of change of pace of life. So are there any key issues that you really need to consider when, doing that?
Sure, yeah, good question. I mean, I think the first thing I'd say, which might not be helpful for everyone, is it's really well worth thinking about it ahead of time, because whatever happens, it's going to be a lengthy process. So you don't want to wait till the day before you retire, because there's no way you're going to get out quickly. And especially for smaller businesses, a lot of the value is tied up in the goodwill, and the owner manager will be a key part of that. So even if you could agree a deal tomorrow, you'll probably have to agree to stay on for at least a transitional period to make sure that the goodwill can be transferred over to the new owners. But yeah, what I'd say, and then the other thing about approaching it really early is getting the company and the business shipshape behind the scenes, because especially if you're selling to let's say a larger business or private equity, they're really going to be, they're very experienced at this, and they're going to be ready to sort of pick apart the accounts and the administration of the company. And it can be easy for them to find excuses either to chip down the price or come back with a warranty claim later if things aren't perfect. So often what I see in practice is that you might have really good accountants and bookkeepers on board that are great at sort of doing your business as usual, keeping things ticking along. But if they're not entrepreneurial or sophisticated, experienced enough at dealing with mergers and acquisitions specifically, they can be a bit naive, and potentially, you know, sometimes I see it where they try and make the accounts look more attractive,
Yes,
to get the initial purchase price higher, but then it can be a bit of a sort of a house of sand that can then bite you later. So I'd say, first, obviously, your existing accountants, if they're good, you know them, you like them, and they're qualified to deal with this kind of thing, always plan A is go with your existing accountants and speak to them at an early stage and just make sure that they're the right people to sort of move from keeping the business ticking over day to day to getting it set up, shipshape, and in the ideal position to sell. And you know, similarly with lawyers and other professionals, but often it's the accountants, that's the kind of the first phase. And then the next question to consider will be, I guess it's obvious, but who are you going to sell to? And you know, in all honesty, I sometimes get clients coming to me saying, look, I want to get out, can you help? I say, sure. And they say, okay, can you find me a buyer? So
yes, we have a lot of people asking us that as well.
I'm really sorry, it's, you know, essentially I can't. You do get some, and there's some entrepreneurial accountants who I work with that, because they have a slightly different angle and they have sort of huge books of contacts and clients, that they might actually know appropriate third-party buyers or people who might be interested. You might need to get a broker involved, you know, a broker with experience of the footwear industry and your specific niche type of business, because they might, again, they have a huge bank of
contacts.
They might be able to find the right one. It might be you already have the contacts, and it might be you know, you might not necessarily think about it, and it might feel a bit awkward. Obviously, you know, it really depends on your own commercial situation, but there might be other businesses
would be interested that you perhaps didn't know that they'd be interested.
Exactly. And maybe, so often it's, I mean, it can be hard to speak to competitors, but it might be complementary businesses. And, you know, the example I gave earlier, where it was actually, let's say, a particularly important client, and the way it worked in the supply chain was that client actually wanted to sort of have another
string to their bow.
And so they're almost the ideal buyer, because, you know, they're not some ruthless private equity firm. They already know there's value in this business for them, and they already know you well from working with you. And then the other alternative is, which can work quite well, is the sort of management buyout MBO, or effectively succession planning internally. So hopefully, if you've been growing your business well, and you do have, you now have a team of senior employees, maybe even directors, it might be that out of that, you can see that there are 2 or 3, or maybe even more, who actually you think, well, hold on, they're the ideal people to take this business on. I mean, because one angle almost always is, you know, this business is kind of like your baby. You want it to go into the right hands. At the same time, of course, you don't want to give it away for nothing because you've worked so hard to build it up. So there are ways of structuring an MBO where either there might be loan finance, so it might actually come from a bank, or it might just be, sometimes in practice, especially for smaller businesses, there's a way of funding it from within the business itself. So, for example, it might be that even though you've retired, you still effectively get paid, you know, maybe quite a big, not salary, but the purchase price for your shares. You know, if let's say the business is worth, say, 3 million quid, and there's just, you know, these 3 directors that you're selling to, there's no way they can access that kind of money. Maybe, as I say, there might be a bank loan, but it might be that you just can't, you know, with the business's security, maybe even the individual directors, they can't access that level of finance. They might pay something up front, but it might be that 3 million is broken down over a long period of time, maybe a few years, maybe 5 years, maybe even 10 years. And as long as we've got the right documents in place, and especially if you can trust these guys to run the business well, it might be that they're having to give away a chunk of the profits every year, the first chunk of the profits every year, to you to pay down, you know, whatever it is, you know, 300 grand a year, or whatever is sustainable for the business. And for them, it's worth it, because although they might not be, that might then affect what profits they can draw out, they know that over a number of years, they're going to end up owning this valuable business. And so that, you know, that may well be worthwhile. And I should say that kind of arrangement can often be a more straightforward process, because especially if they're already directors, they shouldn't have to do full due diligence. You hopefully don't have to give the sort of, you know, 30, 50 pages of extensive warranties, because they know the business warts and all. Yeah,
brilliant. Thank you, Philip. Brilliant. Right, we've got another question here from Sabine. Do you have an advice for to protect you when you order your production with manufacturer and they don't respect the delay of time delivery, or the factory don't respect the quantity of delivery? So I suppose that's contractual, isn't it, really, in your T's and C's?
Yeah. So I suppose there's 2 sides to this. Yeah. So the, you know, the basic, I suppose legal response is, as you say, Polly, it's in the drafting of the contracts. So you want to make sure that the contract with that manufacturer, ideally, one thing is making time of the essence. If it's an English law contract, which effectively, it makes it really scary for them if there's any delays. But even if you can't do that, you can have, you know, clear deadlines. What we want to avoid is the kind of contract where the manufacturer is saying, you know, we'll aim to get it to you within, but there's not really, there's no real teeth to that. You want to have, you know, really clear deadlines, and then that triggering clear liability. Ideally, penalties. I mean, we shouldn't call them penalties, but you know, if you can quantify the loss up front, you know, that can make it more sort of scary and keep them honest. And similarly with quantity and quality, of course, we just want to make the requirements as clear as possible in the contract, and also the consequences of breach as clear as possible in the contract. Now, having said all of that, you know, that's a great starting point. And then, you know, the clearer the contract is, the more slam dunk a case you have against them. But then, and of course, hopefully they value the long-term relationship as well. But the issue that you can often have, let's say the factory's in Vietnam or whatever, is actually getting them to pay. Yeah. So as I say, if they value your relationship enough, also hopefully within the industry, because even if you're a small customer for them, you can make it more scary for them potentially if you've got, you know, other contacts, and you can potentially sort of put the word out if they're not treating you right.
Yes.
Then you can make it more scary for them, or threaten to in the first instance. And then you know, if you can have an English law contract, that helps. But you've just got the question of, realistically, are you going to either get them to engage with an English court process if the worst comes to the worst, or are you going to chase them through, you know, the Vietnamese or Chinese courts?
It is, yeah.
So that's the worst case. Now, if you can, I mean, look, if we talk about ideal cases, but it probably isn't realistic for a lot of smaller footwear businesses, is if you can get some kind of security from them. You know, one element is just delaying payment, because of course possession's 9/10 of the law. So if, you know, let's say the contract is worth, or the order is worth, you know, whatever it is, 50 grand.
Yeah.
And the contract says that they should pay a penalty of 20 grand because whatever it is, they've delivered 10% too little, and there's severe consequences. Then if you can avoid paying, or at least paying part until after delivery, then at that point you can potentially withhold payment, not on an arbitrary basis, but having a clear claim that's difficult for them to argue with. And then that puts you in a much stronger starting position. I mean, ultimately, assuming you still need to use them, you're going to have to come to some kind of reasonable settlement.
Yeah, no, that's great, Sabine. I hope that's helped answer. And obviously, if you want any further discussions, you know, you can reach out to Philip afterwards. But yeah, it's a question we get asked quite a lot when members ring me with questions. So we've got another one, Philip. You mentioned buying freehold property and then you rent it back to your company. Can you explain a bit more about how that works, what the process would be?
Yeah, of course. Yeah, actually, funny enough, I was thinking about it. The last time I helped with that was actually Streathers, because it can work for all sorts of businesses. You know, so to give that example, sorry, probably better to give a footwear business example.
Well, no, it's like you said, a lot of the law, it's the same whoever you are, isn't it? So
exactly. So when we recently got bigger, better premises in Crouch End, which, you know, we're all very excited about and proud of, and you know, it's sort of not that it's very relevant for you guys, but it's a sort of ex-NatWest Bank, and you know, really great premises. But because, you know, NatWest, like other banks, they're just shutting down premises one after another. They own the freehold, so they wanted to sell and hopefully I don't know how familiar you are with the term freehold, but what that means is it's the kind of under English law, the permanent ownership. So like when you buy or sell a house, that's normally the freehold. And this is similar. So they owned this building, they wanted to sell the building. And it was, you know, perfect building for us. Now, you know, we didn't necessarily have a spare, you know, 1 million quid down the back of the sofa, but we have a good relationship with our bank, and the property was clearly worth 1.2 million, whatever it was. So it was quite easy to get a mortgage, and you know, different for different businesses, but because we're a really good client, I think we got pretty much 100% mortgage. Brilliant. So, and we set up a new limited company just because, I mean, there's a few reasons why. Every situation is different, but for us, it was a number of the partners being involved. And potentially in future, over the years, it might be that other people join, buy in, or other people leave or whatever. So with that company, it's kind of more flexible from that point of view. So we've got this new property company that owns the Crouch End building. And then we've got Streathers Highgate LLP that is, that's the firm that I'm a partner of. That's the equivalent of your footwear business, the trading entity. One Crouch End Hill Limited owns the building, but obviously it doesn't want to trade out of it. It says, right, we need to fill it, we need a tenant. So there's a lease. I think we did a 10-year lease, but it can be whatever you like. Yeah. On commercial terms, it's like an arm's length, the equivalent of an arm's length lease, and the tenant is Streathers Highgate. Yeah. So Streathers Highgate LLP will pay a commercial rent just like we would to our third party landlord, and that rent will cover, or hopefully more than cover, the mortgage payments. Yeah. So what that means is Streathers, it's great for Streathers because Streathers has this great building and doesn't have to worry about dealing with an RC landlord, and it's great for the partners or the property company because it's got without having to shell out lots of cash, it's gradually paying down the mortgage. So that, and I can't remember the time, it might be 15 years, whatever. In 15 years' time, suddenly you own a very valuable property with good income. Hopefully it will have gone up in value over the intervening period. But even if it hasn't, you've got this, valuable property that's. And that's why I think I mentioned about a pension pot, because you might choose to keep owning it, and then that means you've got that rental income coming in
regularly. Yeah.
Equally, you could choose to sell, and at that point, you've got a really valuable asset to sell. So you can get big capital gain from that.
Yeah. Okay, brilliant. Thank you. Right, we've got one more question. What are the main things that need to be covered in a shareholders agreement?
Yeah, good question. So I suppose one thing to say is that every shareholders agreement is different, and it does depend on the circumstances of your business. But I guess there are a number of common threads, and so one thing, let's say, and obviously they come in different shapes and sizes, but let's say we're talking about 3 or 4 individual shareholders, who might be all founders, or it might be that some are the founders, owner managers, others are investors who are coming on board. But either way, you'll generally have, I guess one thing is kind of the rules of the game, if you like. So what kind of big ticket decisions need to go to shareholder level, and either unanimous shareholder consent or an agreed percentage, because you might say, look, it's just unworkable, especially if there's 4 or 5 more shareholders. If one person disagrees or is away on holiday, we don't want that to stop us doing it. Okay. But normally that's quite big ticket stuff. So it'd be the kind of thing, because it's kind of getting that balance between letting the directors run the business. You don't want to have to go to all the shareholders every time you need to order paper clips. So for example, in terms of value of contracts, you want to set it at a level where essentially everyone would say, well, yeah, of course we should get together and agree it. And obviously, really big things like winding up the business or buying another business, need shareholder consent. But then equally, I think often one of the most important areas is around transferring shares.
Right.
So it's firstly, if one shareholder wants to exit, which isn't necessarily that easy with a small private company, but normally we would at least have a right of first refusal for the other shareholders, because let's say shareholder A has found some, to give a silly example, kind of dodgy mafia boss that wants to buy shares. The others might not want to go into partnership with that person. So at least shareholder A should have to offer his shares to all the other shareholders on a pro rata basis.
First,
So you've
okay.
got a right to pay to play. Or in some cases, you might just have it sort of more blanket than that you just can't sell shares without shareholder consent, which might be, say, 70% shareholder consent. So basically, everyone has to agree before you can do it. And then coupled with that, you might have tag along rights, which is so a little bit technical, but essentially it's the thing where if you find a buyer that offers an amazing price for buying the whole business, you might not want one or two small shareholders to scupper the whole thing because they say, actually, I don't want to. So you set a particular majority, which, as I say, depends on the individual company, but let's say if 70% agree and think this is too good to be true, they can force the little guys to sell, but only at the same price per share. So it's kind of fair to everyone. And tag along is the quid pro quo for that. So if it's the kind of mirroring right, that if you've got that buyer that is willing to pay, whatever, £1 million for the business, but actually they only really need 80%, then the big shareholders might think, well, hold on, we can have all that £1 million to ourselves and leave the little guys out of it. But the tag along right means that the little guy can say, hold on, if you're selling a majority of the business, I have the right to insist that you make the buyer buy my shares at the same price. And then you've got still on transfers. So this is often the biggest thing, is thinking about compulsory transfers. And, what happens if someone dies, or just quits, doesn't want to be in the business anymore. If they're an employee shareholder, they might have to give their shares back, but you might have good leaver, bad leaver provisions. So they might get fair value for their shares. Or let's say if they quit to go to a competitor, might effectively confiscate their shares. If there's breach of agreement, if someone's insolvent, that kind of thing. You need to think through the mechanics. How do we want to deal with these kind of issues? And in a way, similarly, issuing new shares, especially for minority shareholders, that's potentially scary, because if you've got 100 shares in the company, if I've got 10 shares, I'm a 10% shareholder. If the company issues another 1,000 shares tomorrow, suddenly my shares are kind of worthless overnight. So you often have similarly like a right of first refusal or a special majority consent required before you do that. Because of course there might be good reasons if you need a lot more investment to issue a lot more shares, but as long as it's not prejudicing the minority. Having said that, if we're acting for the majority shareholder, we might make it, much more draconian. Because actually, and this can often be fair, if you're 100% shareholder giving away, say, 20% to key employees, it might be, everyone might agree that, yeah, of course, you should still have control. It's more like a financial incentive to the little guy. So you might have reduced minority shareholder control or protections in that case.
Interesting.
There's a number of other issues to consider as well, but I don't want to bore anyone too much. Obviously, come back to me if it's something.
Because we do have a lot of questions like that. We've got a question here from Dan. Sorry, this is going back to the kind of the previous topic we were talking about. Dan said, if you have a private pension, you can also get your pension to buy it and pay a commercial rent back to your pension pot.
Yeah. Good point. And that's something that I've helped clients with. Say a SIP or something like that. So as you say, it's actually the pension pot then that buys the freehold and becomes the landlord. But it essentially works in a similar way then. That the trading business is paying the rent to the pension, and then that is providing funds for the pension.
Yeah, understand. Yeah, great. Brilliant. Thank you. Any more questions? No? Well, I think you've covered everything. No, that was fantastic, Philip. Thank you. And we were really keen to do a legal webinar because, a lot of the questions, especially with the small SMEs, are legal requirements. Because like I said, most people are really good at their business, whatever it is, with painting, footwear, but then there's so many things within law that people don't understand. And I always think it's a bit mystical. Do you know what I mean? Everyone thinks, oh, it's more scary than it actually is. But that's been fantastic because you've been really, really methodical in taking people through. So If anyone has any other questions, please reach out to us after the webinar. I can put you in touch with Philip, or you'll find him on the BFA website resources. So thank you all for joining us. We always love to get any feedback on webinars just so we can improve. Obviously, the BFA are here for you, and that's why you pay your membership. If you're not a member, please reach out to me so we can get you onboarded. And then just to let you know that the next webinar we've got is the quarterly footwear forecast, which is a brilliant insight into market trends. We have freight advice, FX advice, so it's a really key one in the calendar, and that's on the 7th of July at 11 a.m. So thank you again, Philip, for joining us. You've been fantastic. Thank you all, and we shall see you soon.
Good stuff. Thanks, everyone.
Thank you. Bye-bye.
Bye.